You want to start? Good morning. This is Raylene with the Incarceration Prevention Reduction Task Force Legal and Justice Systems Committee. It is 11:32 on August 8th, 2023. We're going to begin with the land acknowledgement statement. Before we begin, we acknowledge that we are gathered on the traditional and unceded territory of the Lummi, Nooksack, Samish, and Semiahmoo people who have cared for and tended this land since time immemorial. Truth and acknowledgement are critical to building mutual respect and connection across all barriers of heritage and difference. We begin this effort to acknowledge what has been buried by honoring the truth. We pay respect to the elders, past and present. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that brings us together here today. And please join us in uncovering such truths at any and all public events. So today's agenda is going to be kind of focused on some information that Maya Vanyo is going to share with us on public defense needs. I did send out earlier, or had Jill send out, thank you, Jill, public defense standards for Washington State Supreme Court. That might help you guys understand some of the requirements that are needed for public defense, and Maya will explain some of the struggles we have. So if you would like to take it away, Maya.
Sure. Hey, everybody. Some of you may have heard some of this before, but I'll kind of do some big picture stuff because maybe, I don't know if there are members from the public who are here that may not be as familiar, but Jill circulated the Washington standards for indigent defense. I'll just let you know that the American Bar Association is going to be publishing some new national public standards for public defense that have just gone through peer review. They did a Delphi study and I haven't seen the publication yet, but it's expected to be released in September. And from all sources, I hear that will probably have significantly reduced the number of cases that public defenders are advised to accept. How that will have impact in Washington kind of remains to be seen, but it's likely that and what has sort of happened historically is that the Washington State Bar Association adopts or creates standards that comport with the national standards, make recommendation to the Board of Governors for the bar. And if the bar accepts those, then they would make a recommendation to the Supreme Court to make those standards go into effect through court rule, which is what we have now, but to modify those. And I mean, other states are talking about implementing like a several year implementation of these new standards because they're going to require funding if they're asking to increase the number of defenders proportionately to the number of cases. There may be opportunities for federal funding, but I think that there's also going to be a need for state funding, which isn't historically happened for public defense. Public defense is really a locally funded thing here in Washington. I know that there are legislators who are meeting to discuss bills that could involve the state increasing their portion of funding, and that's something that's being discussed. And it's ripe, but that's something that I think needs to be worked on as well. So that's sort of like big picture, what's happening nationally, and then how that might trickle down to Washington. Locally right now, we have a lack of attorneys. I can't speak for assigned counsel. You know, I mean, Dave Reynolds would be best situated, and there may be questions and concerns that could really only be addressed by him. But in our office, you all probably know, but we represent folks in district court and superior court. In district court, we have 4 attorneys and 1 supervisor. The supervisor does have a full caseload. He ideally would be at a half caseload, and we keep trying to push him down to a half caseload, but he also keeps assigning himself cases. So that's a constant struggle. But right now we have 5 attorneys practicing there. One should be at half caseload. We're seeing an increase in the district court filings coming out of COVID, but those attorneys are not at capacity. The current standards for indigent defense say that a district court or misdemeanor only attorney can handle up to 400 cases a year. In our estimation, that's far too many, and we try to keep our attorneys at 200 cases a year because that's what's actually manageable. But we're not bumping up against standards in district court, although we're seeing an increase in filings there. And that's something, you know, I know that the attorneys there would like to have some additional help, but that's not where we're most at crisis. In Superior Court, we have 13 attorneys. We have 2 attorneys that are doing juvenile work, and one of them accepts some sort of youthful offender adult felonies. There's Stark and myself, and since I supervise those 13 attorneys, the standards suggest that I should not have a caseload at all. I do have a caseload, but not as high as everyone else's. Stark has a pretty significant caseload with serious cases. The standards, as were circulated, say that felony attorneys should accept no more than 150 cases a year, and here in Whatcom County, and that's the maximum, right? And so I always want to put that into perspective. Like, it's not really a good idea to require your employees to work at 100% capacity 12 months out of the year. That tends to push people to burnout, and they are not doing probably their best work. So, you know, 150 is the cap, but the way public defense works is people tend to try to push it to work at the maximum capacity. That's, I think, far from ideal, but nevertheless, we do reduce the 150 case credits for some recurring calendars that our attorneys have to appear at each week, because that eats into the time that they can appear or work on cases. And we have a case waiting policy here in Whatcom County that's recommended by the standards. It was adopted by our council a few years ago now. And what that means is a forgery case is 1 case credit, a homicide is 3 case credits, and Class A sex offense is 3 case credits. So it's weighted based on the seriousness of the case. The attorney assigned gets that credit one time only. It's not like a recurring credit that happens every year. They get that when they're assigned to the case, and that's for the life of the case. The case waiting policy does allow attorneys to ask for additional credits if there is an exceptional amount of work done. And that would probably be pretty generously approved by management, but it's very rare that the attorneys ask for extra credit. I really can only think of probably one handful of times where attorneys have come to me and said that the work they're asking for extra credit. So really, it's just what's in the case weighted policy is what people are getting. We do assign for the most serious cases, we will assign a second chair so that there's a second attorney working on it if it's a really complicated case. And then that second attorney does get case credit for working on that case as well. We have a felony lead and a training lead. So those attorneys are there to assist all of our lawyers, and they get a slightly reduced caseload, as do the attorneys who practice in recovery court and mental health court, because those just take up a lot of time during the week. We frequently have attorneys go out on leave, which was normal for any employer, right? We've got folks who are going out on FMLA, or they have a kid and they're taking that time, or whatever. So that happens a lot. So I would say that, I mean, I don't even know. Like typically I've got one of those 13 lawyers is maybe out on one of those leaves. I would say, like, there's a couple months of the year where everybody's here in full force, but it's not uncommon for me to have one or more attorneys who are taking whatever leave they're entitled to. So that is another factor in how many actual people we have. Let's see here. Well, I mean, I think it's like however many attorneys we have working in a given month really defines how many cases we can accept in a given month, because we really have to assign the cases pretty uniformly over the course of the 12 months that's subject to the standards. Otherwise, you get to, if you give somebody 40 cases in January, you get to December and they can't accept any cases, and then they're getting 0. So it's really, the standards say you're supposed to assign them fairly regularly throughout the year. And that's certainly what we try to do, so that we're not stuck with folks at the end of the year that couldn't take anything. You should know that 10 of our staff are funded by ARPA funds that were made available during COVID. There were 5 attorneys, 2 investigators, a behavioral health specialist, and 2 legal assistants. Those attorneys that staffing is allowing us to just kind of barely keep at water's level, and not be underwater, although we are, as I'll explain in a little bit, sending cases back as overage, even with the staffing levels that we have right now. So, but our priority right now has to be, we can't even really look to are we able to increase our staffing to get above water, because we're concerned about these 10 staff members who are ARPA funded that are just keeping us afloat, and making sure that we have ongoing funding for those. That funding, I think I may have said, but I'll say again, expires at the end of 2024. It's challenging to, another complication that we face is retaining attorneys. When you are working people at high caseloads, and maybe there are lower caseloads in other counties where they could go work, or higher salaries in other counties where they could go work, which both are true facts. It's harder to retain attorneys. And of course, it's significant when we lose an attorney, as we did fairly recently, who's one of our Class A qualified attorneys, because they have a caseload of serious cases that can only be reassigned to attorneys who are likewise qualified. And not all of our felony attorneys are qualified to take Class A cases. And those case credits then have to be recounted. So the initial 100 that attorney, maybe that attorney is carrying 100 cases, we'd have to reassign that 100 within our office and recount them all, which then doesn't make space for incoming cases, because we were recycling old cases. So retention of attorneys is really important. And the things that make an employment attractive are the salary and the caseloads to public defenders. Those are real issues. There's a lack of attorneys in the community to take conflict and overflow cases. So in 2022, I just looked at the court's website, and it looked to me just generally that about 1,500 felony cases were filed in Whatcom County. And then I looked at our numbers this year in 2023 from January through June, so 6-month picture of how many cases we conflicted. And I projected we would conflict about 300 cases this year. So filings of 1,500, about 300 cases go out as conflicts where we can't represent them because they're co-defendants or a victim in a case where we already represent someone. And those have to go out to counsel not associated with the public defender's office. There are also overflow cases that I talked about, and we had about 20 in May. In June, we had less in July, but really because we absorbed a number of them in a way that we could never reproduce, because we kind of overloaded somebody. But we have these overflow cases that are going out. So those additionally have to be assigned to conflict counsel. So what's conflict counsel? The Office of Assigned Counsel manages that. They do the contracts for that. They've hired Melissa Stone to take cases. She's qualified to do juvenile cases, district court cases, and C and nonviolent B felony cases. So she can't absorb those more serious felonies that are out there. And she also has to comply with caseload limits. And I think she's now, she kind of got a big dump when she took the position, and is now having to be more selective about what she can accept numbers wise. Office of Assigned Counsel relies on our community attorneys. Carl Munson, who has historically taken conflicts, that was most of his practice, recently took a job in our office. And so now he's no longer on the conflict panel or conflict list. He's one of our lawyers that's he replaced that Class A felony attorney that left. So thank goodness we have him in-house, but we're just taking from our community of lawyers that's dwindling and using them internally. Another lawyer just maybe a week and a half, 2 weeks ago, gave notice that he's essentially leaving the practice of law, taking a leave, but he went inactive. So all of the cases that he had accepted from assigned counsel have to be reassigned now. And we're looking down the barrel of that because he had quite a few Class A felonies that heavy on the sex offenses, vehicular homicide that Melissa Stone can't take. And so right now we're trying to figure out what number of those we might be able to reabsorb in the public defender's office. But if we do that, that means in August, we will have used up our serious felony attorneys. And then those new cases that are coming in, where are they going to go? So that hasn't even been, we have not sorted that out yet. But that's like a problem that we're facing right now. I know that assigned counsel is trying very, very hard to find contract attorneys that are willing to accept this work. They contract with people in different counties who are appearing remotely. And I understand that the parties are really trying to accommodate that, the court and the prosecutors trying to work with them so that they can do this practice remotely. But I'll say, as someone who works with clients, being face-to-face, being able to go into the jail and meet with your client in person, those are kind of invaluable elements of being in a criminal defense practice. And, I imagine it's quite hard to do this work from another county, but that's sort of what the Office of Assigned Counsel has been left to do in many cases now. So like, what can you do? I mean, if the filings went down, that would really help. That's entirely in the power of the prosecuting attorney's office. What happens when people are going unrepresented? Our position has been that any in custody people that are unrepresented should be released. The state could dismiss the charges without prejudice and refile later when there is a better opportunity for representation by counsel. There was I think that Stark had some back and forth with the bench about this issue about what's going to happen with these defendants who are unrepresented, but there was a rule change, and General Rule 42 has basically taken the bench, the judiciary, out of the role of assigning representation to defendants. And so our bench is reluctant to get involved on that way. I see them regularly setting reviews, which is good. So I guess so that folks who are unrepresented aren't just getting the 3-month continuance. I'm seeing on calendars pretty regularly that the court is setting reviews for representation, but I don't know that, other than setting the reviews, I don't know that that issue is really getting resolved. But they're not getting lost in the system, hopefully, because they don't have a counsel to ensure that that's not happening. This is a problem in various counties throughout the state. I know Stark was telling me just anecdotally about conversations he's had with the defender in Yakima, and who says that they have many more people than we do sitting in custody unrepresented. So this is not just a Whatcom problem, but it is a statewide problem with lack of attorneys to handle these cases. But our people are feeling it. And in terms of like how many folks are going unrepresented right at this moment in time, whether they're in custody or out of custody, I don't have that information. That would need to come from the Office of Assigned Counsel. So that kind of was everything I wanted to for sure touch on, but I could try to answer questions if people have other questions.
Thank you, Maya. I think part of the reason we wanted to address this is, as the task force, we want to try to eliminate people being in custody, and we don't want people to be in custody for too long. Yet if they don't have adequate defense, and they need to have equal access to justice, and they have a right to a speedy trial. Those are all things that courts have to take into account, even with the GR 42 changes. And so if a judge has a defendant that comes into court that wants to have their trial, and they want to do it right away, yet defense has just left that position, it has to be reassigned, that new attorney has to step up and get all the information they have, yet they still want to honor the defendant's request to have a speedy trial, but they want to give them a fair trial. So there's a lot of things that come into play on waiting whether or not it should proceed, or if we need to give them enough time for the defendant to be adequately represented at the time of a trial. And so there's a lot of things that are coming into this, as well as noting when you said that this is an issue with retaining attorneys, at least with the Office of Public Defense. I also see it locally. Some of the attorneys, the prosecution that we work with, North County Public Defense, saying, you know, that they're having issues retaining attorneys, getting new attorneys. It's kind of like the issue with officers and deputies being retained, and there's not enough people out there to fill these positions, and there's a lot of burnout and people changing positions or going somewhere else. So that's kind of why we wanted to bring this to light and see if there's anything else we can do. One question I have for you, Maya, and this could be totally off, but would it be beneficial if the Office of Assigned Counsel for Whatcom County had two offices of public defense, one for conflict and one for the main defendants? I mean, I know they've got Melissa Stone appointed, but
Yeah. Well, we've talked about that. I mean, when I look at the numbers of cases that go out as conflict, it doesn't really look like an office to me. It's you know, it is 2 to 3 attorneys full-time work, but I don't know that that really makes sense for it to be a whole office and everything that goes into the creation and funding of an office, the investigators and legal assistants and office space and just the overhead with it. So I think and if you have more than 2 co-defendants, then you still need a panel. It doesn't really solve the problem because you still need conflict. You still need contract attorneys to take cases. So like a well-managed conflict contract panel would be great, you know, if you could find the attorneys to do that. And how, so it's like, but so we've talked a lot about like, well, would you incentivize that work? There right now, for instance, public defenders are eligible for loan forgiveness, but conflict panel attorneys are not. These may be bigger sort of statewide issues that have to get addressed, but maybe they are things that could be looked at locally. How do you incent? I think there's things, I think it's pretty much financial though, like how much are we paying these panel attorneys, conflict attorneys, and how do we entice them to come and work on our cases? I mean, someone with more policy, I don't know. I mean, looking at whether we have never seen it presented that a second office makes a lot of sense financially, but I mean.
Thank you. Just throwing it out there, an option.
Yeah.
I see Stephen's got his hand up, and Arlene.
Maya, thank you. I get the overall urgency and complexity of this. It's hard for me as somebody not directly involved in that to try to problem solve this. So I'd throw that back to you and ask if there are any ideas you have in a local area, local arena that could make a difference in this in the next 3 months that we could support, and also in the next 6 or so months. And I picked that figure because that puts us into the legislative session. And I think this is, as you said, a bigger than Whatcom County thing. I think money is at the heart of a lot of this. So I would just look for any brainstorming that you and Stark have done that we could sort of get behind and help push?
I mean, it really is Dave Reynolds' job to organize and find counsel for through the Office of Assigned Counsel. And he doesn't, I'm not brainstorming this with him, but I assume that he's like, I look at in Skagit, for instance, their conflicts are handled almost exclusively by an attorney who's paid through who's a Snohomish County public defender employee. Like I don't know.
Just to interrupt, I'm not thinking just of the assigned counsel part of it. I'm thinking about your staffing and replacing the ARPA positions.
I mean, the funding to replace all of those ARPA attorneys is our priority going into any budget discussions. I mean, we have to start there. It's the most basic, but it's a lot, but I know, I think, and Eric is here, I think that he can talk also maybe about what he sees as some staffing deficiencies in his office. And we know that council agreed to hire more sheriff's deputies. And when you have the engine of the train being law enforcement, when you increase that, you cannot ignore the downstream effects of that. So I think there's a need to consider how robust our response is to that, and that's above and beyond what's going on with the ARPA, funded positions. I don't know if Eric wants to talk to that at all, but we have to be responsive to what's happening farther down, upstream in the criminal legal system. So, we're talking with the exec's office and letting them know what we see as the deficiencies and what we need to be asking for. And I know that there's some meetings planned with the prosecutors and the execs and us as we approach this mid-biennium budget cycle to try to wrap our heads around and come to some agreement about what's going to improve the situation.
Thank you, Maya. Arlene, and then Dave Freeman.
Yes, thank you, Maya. I guess it's clear what's lacking or the deficiency here, but it's the planning for changing it that I guess we're here for, to try to talk about that and organize it and even set it into motion if possible. So we need information like how much money is actually needed to make the sufficient changes in the system of staffing and whatever support systems you have, a range at least, so that when it's presented to whoever the budgeting people are, they can have a clear picture of that. And then when it comes to hiring people, one of the things that I've noticed in the Northwest is that I've talked to some physicians about why they came to the Northwest to do their work, because they said their salaries were lower than in other places that they could work. And what they said to me was, the lifestyle here is extraordinary, which all of us know is true and is a tremendous selling point for young professionals with families who want a wonderful environment for themselves and for their families that they're raising. They want a lifestyle, and that is something that can be promoted and sold to them as a real value. But of course, ultimately, you have to give them decent salaries too, and it has to be kept up with. So it's specifics that I guess I'm looking for.
Well, those numbers, I think, is what we're going to be meeting and discussing with the executive and coming up with a strategy on what to be asking for in the mid-biennium adjustment. We are not Yakima. We are advantaged in that way. We do get some applicants, not a lot, like one or two, but we have been able to fill by the skin of our teeth, but and because we live in Bellingham, I mean, it's wonderful here. I agree with you. You know, the lifestyle is really important, but when a county to the south is paying their senior deputies $20,000 more a year than we are, it's still, that's pretty appealing.
Yeah.
You know, I mean, we can't compete with
Sure.
that. Really,
No,
you
of
know?
course. Right.
So like there's and that's, you know, those are things that are shifting, and you know, like that county is responding to the fact that we always paid slightly more, right? So it's like it's this, but the market is so tight right now that that's where like there's a real deep competition going on, and it is something that we have to be kind of nimble about, or we'll be left behind.
Yeah.
And the other thing I would mention is, and I see Eric raised his hand, that's great, is diversion programs, and really creating those and using them. And that's, you know, we just need less cases coming in and more people being diverted to services. And any creative thinking there is wonderful. I would help support in any way that I can. That's what we need. Thanks.
Thanks again, Maya. Dave Freeman and then Eric Ritchie.
Yeah, thank you. And thank you, Maya. I just had a couple of observations from what Stephen had asked. And I'm going to be cautious here because we were removed from assigned counsel as of this year by general rule. So I'm not advocating for anything here. I just, my own observations from the bench. And I'll start with, clearly when we have overflow cases, then there is a lack of funding in the PD's office, because as Maya said, you know, they're more likely to be able to retain these attorneys because there are benefits. They're not conflict counsel. And I don't think assigned counsel was ever set up in a sense to take overflow cases. This was supposed to be a conflict office. And we were involved up until last year. So I have direct observations of it up until that point. And I certainly don't want to speak for Dave Reynolds now in his role with the executive and clerk's office. But, you know, that office really wasn't set up for overflow cases. It was meant for conflicts. We have, as Maya said, had a substantial decline in attorneys available to take conflicts. Just in the last month, we've lost 3. Just in the last month. Before that, I would say we had 3 or 4 that we had lost in the last year. It is extremely difficult, and I know Dave Reynolds is reaching out as far south as Pierce County to try to find attorneys willing to take conflict counsel cases. I don't know if it's, you know, and again, this isn't, I'm not advocating for anything here. I don't know if it's how much the county pays for these conflict cases. I don't know what the resistance is or the lack of availability. I do know we're not the only county struggling with this problem. So I'm not sure funding is purely the solution or answer there. From the bench perspective, we are really struggling, and to, you know, Stephen, one thing that we have tried to do is reach out to our local bar. I do hope that will continue, and any community input from the local bar would be hugely beneficial. I'm going to try to reach out again. We've had emails go back and forth. Maybe speak at the next bar meeting.
Yeah, and Your Honor, if anything like that is going to happen, please invite Stark or myself. And you know, I try to occasionally go to those meetings, and I'd be happy to join in that voice.
Yeah, and we have sent emails, and they've been forwarded on about the desperate need. The role of the court has been largely diminished in this case, but like Maya said, we're still putting these on for reviews, and we have very limited options about either release, dismissal, if it becomes too egregious, or appointing an attorney unwillingly from the bench. And we have tried that, and it has not been all that successful. I'll just say that. I think out of the 3 that we've done that with, 2 have withdrawn. So that has not been the solution either, appointing somebody who is not voluntarily taking the case.
Is it possible for attorneys to do part-time work and keep their private practice and work a certain number of hours as sort of a contribution to the community?
Yeah, and that is part of, I mean, I don't want to get too much into the ethics, the bar standards, but you know, there are some ethics involved about being able to take these types of cases if needed. to serve in the community. I do think that there are qualified attorneys out in our community that could take 1 or 2 cases here or there, but could make a huge difference by doing that. Particularly if they were taking even some of the misdemeanor and gross misdemeanor cases, to allow some of our conflict attorneys to focus more on the higher level offenses. That's something that I think we do have more qualified attorneys out in the community that could do and relieve the more regular conflict. Again, I'm not directly involved with the conflict list, but I can beg and plead with our bar to please continue to take cases when you can, even if it's just a case or 2. And that's my plan going forward. And obviously, we'll have kind of a limited role in what we can do if it becomes too egregious, but it's about all I can say, Stephen.
Thank you, Dave. And Maya, Eric Ritchie?
Yeah, can you all see me right now?
Nope.
Okay, I don't know what's going on. I don't know what is going on with my Zoom. I struggled getting on this meeting. I think I need to have IT download something. I can't download things on my own. It's just kind of where we're at with systems here in the county. But so anyway, but I want to talk about numbers. I don't know exactly what the question was, but I do want to talk about that. Of course, this office, we support the idea of the public defender meeting caseload limits. That's really important. You know, I know that they've struggled with that. I know that we've had to get conflict attorneys, and we're struggling getting conflict attorneys because the numbers, and it's just a mess. I think that we're struggling partly because of wages. I think that's the only real answer. But you know, I have to talk about where the prosecutors are at too. And I don't know if you're all aware of the situation, but I'm going to make you aware right now. Here in Whatcom County, we have 187 felonies per felony attorney. That's going on at any given time. And the normal caseloads for felony attorneys is around 70. And so anyway, we're double plus what should be the normal caseload. And that's really concerning. I mean, it's about our community not getting the right amount of justice. And we're talking about victims not receiving the right amount of justice. And of course, you know, it's just, it's not good for the, you know, to protect our community that way. You know, I know that Maya's talked a little bit about how things kind of flowed downward from the number of deputies on the road, number of prosecutors. And I think that we're going to have to address that after we fix what's gone on in the prosecutor's office. I mean, we're talking about the public defenders being set at a normal caseload limit. And again, we support that, but increasing the prosecutor numbers would put this public defender office at a normal amount of prosecuting attorneys that the other counties have. So our public defenders would be facing off against the same number of prosecutors that would be, you know, a regular amount. So I don't know what kind of, you know, downward pressure they'd be feeling from adding prosecutors to this office. Now, as far as wages go, I have to address this too, because this is something that's very frustrating. You know, I've struggled with this in Whatcom County for the longest time. We in Whatcom County pay people less because we can. You know, we you know, Arlene, you talked about how you know, the doctors, they take a pay cut because they get to live in wonderful Whatcom County. And you know, we do appreciate that, but it's not fair. It's not fair to say, hey, yeah, hey, you all get to live here in this wonderful land, so we're going to pay you less. And that's the way Whatcom County has been rolling for so long, and that's got to stop. I really struggle with that, and you know, especially right now, because as Maya said, you know, hiring is suddenly getting difficult even for us. You know, we have been able to hire because we have one. We do get to live in wonderful Whatcom County, but it's you know, we went with a district court position open for 4 months before a single applicant came along, and we took her. Turned out to be great, but it's you know, it's not the way the system should work. And we're struggling with retention. You know, retention, people are leaving and they're threatening to leave, and they're you know, they're looking down south. They're looking at Skagit County and Snohomish County, where wages are $20,000 more per year for an experienced attorney. It's tough. And I'm not exactly sure what I'm doing right now other than complaining, but I also feel like you all need to know what's going on in our world.
Yeah.
All right, with that, I'm done. Thanks.
Thank you, Eric. I really appreciate you giving us pictures from both sides. Stephen?
Yeah, not a short-term crisis response, but one thought to throw into the hopper. And as background, last December, the Task Force's Behavioral Health Committee came up with a priority legislative agenda that we wanted to push with our legislators in Olympia. They didn't, it was too late for them to get on board. It wasn't aligned with the executive's agenda, and it wasn't aligned with the State Association of Counties legislative agenda. So we decided we needed to be talking together and unify an agenda for the coming legislative session. We wanted to start in the summer. We haven't done that. But someplace soon, I hope there's going to be that conversation. And Eric and Maya and Stark and Judge Freeman and Dave Reynolds, I think this needs to be in there, pushed to the Association of Counties lobbyist, because it affects more than just Whatcom County, and it ought to be up near the top because as Maya suggested in her train analogy, this really affects so many points on the continuum that we can't make progress with unless it's addressed on a bigger level than just a county level.
Thank you, Stephen. I also want to mention that something that wasn't brought up, but with all these changes, legislation, cost of living, everything that goes into hiring attorneys and bringing new people on and retaining them, we didn't talk about the legislative changes that have affected both prosecution and defense with the body cam requirements. When a defense attorney or prosecution received a police report 2 years ago, it might have been 5 pages. It might have been 20 pages for them to review. Now you have 3 officers show up. You have 3 supplemental reports along with the main report. And then you have all the body cam video footage that really should be reviewed. All of that should be reviewed by both prosecution and defense. And then you have everybody in town has a Ring camera or another video, and they throw that in there, and sitting down to watch all of that video footage and then give adequate representation to a defendant as well as to victims that want justice, but maybe aren't getting it because there isn't a conflict attorney available or the caseload standards haven't been met. And so the judges are sitting on the bench. Do we dismiss this case because this person had a right to an attorney and they had a right to a speedy trial and we can't meet those requirements right now? Do we hold it out? I mean, there's so many different questions and things that are involved in making sure there's adequate representation to a defendant that needs to have equal access to justice. That this is something that we can't hold off on. And I think that it's something the Legal and Justice Committee should continue to pursue, to look at for legislative changes. I don't know. I mean, from the court's perspective, I look at myself, as Judge Freeman said, this is something that they've kind of removed us from, but we also have to remember we have to give equal access to all individuals. So that's my 2 cents on it. I don't know if Eric or Maya want to chime in on any of that, but
just to put a little direction, it's Senate Bill 5773 that Senator Torres was the sponsor on that if people want to look at, I don't know what it'll look like eventually, but if the idea is that I think there's a 10% 1 year, 20, 30, 40, up to 50% contribution from state funds into public defense so that we're not relying entirely on local funds. So that's 5773. If people want to just scope what that language looks like. And I've brought that to the attention of the exec's office, and it's our public defender advisory committee was just provided a copy of that. And I think that yes, that should be a legislative priority for the county to support and try to get that passed. So it's out there in the world. I don't know that anything will happen in this session. That's, I think, an election year, but the discussions are beginning. It's not a quick solution though. It's not a solution to the 10 ARPA positions. It's not a solution to the overflows that we're experiencing right now. We have to kind of address it locally initially. Thanks.
Maya, do you think that your budget needs to be doubled?
I don't think I can say that. I can't say
I'm
that.
serious for asking
I
that
mean,
question.
no, I'm sorry to laugh, Arlene. I don't mean to be laughing because I appreciate that I would even like have that inquiry. I can't say that. I think that is what Eric and the exec in our office are sitting down in the beginning of September to really try to crunch, like, what does the ask need to be? And I can't really answer that right now, except that I can say there's 10 ARPA positions for sure. And while Eric doesn't think there will be an effect on the public defender's office, if he's given 6 more lawyers or 4 more lawyers or whatever ends up happening, there will be an effect on our office because our attorneys will be in trial more, which makes them unavailable to work on cases and meet with clients. I mean, there is a ripple effect. It would have an impact on us. We need to work. We are working together and trying to come up with some of an ask, that will hopefully improve the situation. The conflict counsel situation with the Office of Assigned Counsel is a separate thing that I can't really speak to. Like, I don't know what Dave's going to ask for. I don't know what his plan is. It's really outside the scope of, I have enough sort of in my internal plate to try to navigate. I'm concerned about it, but I can't make solutions there.
Thank you, Maya. Eric?
Yeah, sure. So I can tell you a little bit about what we are doing. We are asking for 12 new positions, and that would be 6 attorneys plus support staff that would help the attorneys do their work. And I think really nailed some things here when she talked about how complicated our caseloads are these days. The body cams, the ring cams, these are pieces of evidence that need to be looked at and evaluated for us to determine what our cases are worth. And that's changing the work that we had. It's more difficult than we've ever had before. This amount of time, it's the analysis, and I think these cameras, they allow us to get better justice for sure, but making sure that we're getting it done is really a process. And with this complicated evidence, it's also about discovery, and I think Raylene touched on that when she's talked about cases getting dismissed, and that's because we're not getting discovery across to the defense in the way that we're supposed to. Not because we're holding things back, but because mistakes happen. We have people that are working specially in the area of discovery to help curb that from happening. And I can tell you, it's not just Whatcom County Prosecutor's Office struggling. It's every prosecutor's office in the state, and I would suggest it's every prosecutor's office in the country. We're all having a difficult time moving this complicated information, not only to the public defender, but getting it from the officers to us and then to the public defender. So it's quite a process, believe me. So we are asking for more help, and that's, I think, it's very important for our safety in this community.
Thank you.
Yeah, and I mean, the comments about body cam are 100% true. I mean, we used to, I think that our chief investigator could probably quantify like the number of hours of video that we receive now on like a weekly basis or per case. I mean, there's probably some average, I don't know, but it's extraordinary. Like just we started with like a hard drive that we would download them onto. And then it was like, well, no, we need 5 hard drives, and wait, now we need this whole program, and we've outgrown the IT space. And I mean, it's been incredible just navigating the technological aspect of like, how do we preserve and keep this evidence and how as required. But watching it all, it's just an enormous time investment. And another element is just the number of folks that we have with serious mental illness. It's so many of our clients are contending with this, and that the amount of time it takes to communicate and work with those clients is just more. It's harder and longer. The cases take longer. The number of meetings, the explaining, the seeking community resources, it's all just way harder. It's way more work.
Thank you, Maya. And just to touch on what you just said, with some of the individuals with mental illness, we run into it where we have a need for conflict counsel because they've already been involved, or a significant other has been involved with our normal defense. So we have to find conflict counsel for some of these people. And I know just dealing with some of those individuals that call our office on a regular basis, you know, it takes a lot of time, and you don't want to dismiss anybody, and you want to help them. And then you know that you're not supposed to be finding conflict counsel from the court's perspective. So now that's from a different office. And then you've got conflict counsel that is making a lot more money on their regular paying clients. And then you're going to say, hey, by the way, can you help us out with a case with an individual that's got some severe mental health issues, but has been found competent and needs representation. And the struggles to find an attorney that wants to represent that, it's not easy. It's, you know, it takes a special person to work with some of these individuals. And we really do applaud the attorneys, because it's not easy. I know it isn't. So thank you.
Thank you, Raylene. I'll pass that along.
I'm gonna wrap this up because we're almost at the end of the 12:30, and I just wanted to briefly go into other business. Myself, Darlene Peterson, I know our DV advocate, and many others attended Sam Quinones' speech recently. That was done by the Whatcom County Behavioral Health, is it Chuckanet Health? Sorry if I'm saying that wrong. It was a really good presentation. I think there was probably over 400 people that were at the Bellingham High School on Tuesday discussing opioids and fentanyl and the changes to synthetic drugs, how that's affected this community. For those of you that missed the presentation, I believe that it was recorded, and I'll see if I can get a copy of that from Heather Flaherty. She might have information. Stephen's shaking his head. There's going to be more discussions on that at the Bellingham Public Library August 14th. I believe that's noon to 1:30, and then or 5:30 to 7 Thursday, August 17th. Something that came out of this was making sure that the community is brought together and to try to work as a group instead of a division. And I think that was really important. Maya, you still have your hand up, so I'm going to go back to you.
Thanks. Well, in other business, I just, I don't know if this is the right meeting for it or not, but Stephen, I know that, I think I understand that you and Jack are reaching your term limits as chairs, and I just heard somebody said, oh, I heard that IPRTF is basically done. I mean, Stephen's done. So, you know, it's done, it's over. And I was like, oh, I don't know. Maybe there's a committee that talks about this, but I'm like, when is your term over? And do we have like is there a plan for transition to other leadership? And what is the continuing mission? I assume the mission continues. It certainly doesn't seem like we've resolved everything. Is there a plan?
Yeah,
Is it appropriate to discuss that here?
Yeah, but maybe not at this point. The situation is Jack's and my terms both expire with the January meeting. So we are termed out. there have been a number of discussions and a number of ideas floated for possibly extending us for a year or more for continuity's sake. All of those have been shot down by Karen Frakes as inconsistent with the county charter. So we will be going off. We will need new leadership. The ordinance and code provision for the task force is open-ended. So no, the task force is not shutting down. Its work will continue, and maybe as important as before, especially with the oversight function for the ballot initiative if it passes. So probably the right forum for this, as I've suggested a couple of times, is the steering committee. There's an informal subgroup meeting this week to try to sketch out a proposal to the steering committee for what we're looking for, how to recruit people, how to vet people, how to decide on new leadership. So I'm hoping that the next steering committee meeting, which will be in September, will probably have a proposal coming out of it to the task force for consideration. And glad to have non-quorum conversations with anybody else about where that conversation gets, or ideas that other people may have, or people who are interested in that. It may not be obvious to everybody, but it's a pretty complicated multi-skill set kind of role to ask people to play. And since many of our task force members already have more than full-time day jobs, it would be a really heavy load for a lot of our people to carry, even if they had that skill set. So more to come, but yeah, you're right, Maya. We are terming out. No, the task force is not done.
Thanks for the update. I'm glad to hear those things, and you'll be sorely, I mean, I hope you won't be gone, but you'll be sorely missed in the role you're in now. So thank you again.
Thank you. I can still lurk around on the committees as a non-member.
Thank you, Stephen. Eric?
Yeah, I just wanted to touch on something that you said, Raylene, and that was talking about the Sam Kionis event. It was great. I think that he said some things that we've been talking about in this community for a while, and that is talking about some treatment while folks are incarcerated. And I think that that's something that we need to really be focusing on as we're talking about this new jail plan. You know, I know a number of folks from the task force went to Nashville or have been talking about the kinds of facilities they have in Nashville. Listen, I'm all on board. I think that this is this diversion program that they have in Nashville is exactly what we need here in our community, and it's something that we need to focus on as a group.
Thank you. I think that's definitely something we should be looking at for future meetings. I was fascinated with the Ohio pods, I think it was in Ohio and Kentucky that Sam had talked about. I did send a copy of the Atlantic to Jill to forward to most of you. That kind of summarizes a lot of his speech that might be helpful to kind of understand if you missed it. It is a fascinating read. The book, The Least of Us, was his most recent one. I read that. That was awesome. I got the other one, Dreamland, sitting here, along with about 6 other things I need to be reading, but well, I'll get to them when I can. So is there any other business that anybody else would like to touch on? Oh, Maya.
Sorry, I just one more over then. I appreciate Mr. Quinones, I really do. But I want to also just reinforce the thinking that we really need community voluntary services. And we should be focusing on that before we're talking about jailing people to get services. We'd have, like, just remember, it's like we have to have it available to folks voluntarily, and we don't. And to jump to this, I just would urge some caution. But thanks for letting me get my little piece in.
No, I appreciate it. I liked the thought of transferring people on re-entry to help outside. And I think that's something that we've been talking about in the past, but we need to look at moving forward so that those people that have been incarcerated we don't have the high recidivism rates. So thank you. Is there any other business? Okay, Jill, do we have anybody in the audience that would like to jump on?
We do have a number of attendees, one whose hand is raised. Jason, go ahead and speak to the committee.
Hi, good morning, folks. Jason Forrest, local business owner. I just wanted to attest to the experience of a defendant who has been in the Whatcom County jail and through the Whatcom County Superior Court system. I'd like first to say that it's most important to remember that not all defendants are innocent, but all defendants are innocent until proven guilty. In the time that I've been in the Whatcom County Superior Court system, I've been through 4 different public defenders since November of 2020. In that time, I've spent 18 months incarcerated, not being found guilty, nor having a trial yet. We don't know that all of the charges that are being charged are accurate. And I think we need to make sure that the rights of the defendants, although we don't know who is guilty or not, be respected to the utmost, because what you're doing is putting these folks in the most disgusting, inhumane conditions for a matter of time that they can't get out of. And this has tremendous effects on people. The amount of life and time and pain and suffering, lost wages, damage to personal image, post-traumatic stress disorder inflicted on these people, it doesn't go away. It stays with them forever. And I think we also need to address the overall culture of the Whatcom County Superior Court. I think that's been left out. In speaking with folks who have worked at the public defender's office previously and who no longer work there, they no longer work there because of the culture. And that needs to be spoke about. To speak to an incarcerated person's perspective, I personally witnessed inmates taking deals just so they could get out, not because they were guilty or innocent, but just so they could get out of the conditions that they were in. That's not justice, folks. Thank you.
Thank you, Jason. Are there any other attendees who would like to speak to the committee? Please virtually raise your hand now. And no additional hands are raised, and I don't see anyone attending in our conference room. Thank you.
Thank you, Jason, for your information to the committee. It's appreciated. Thank you, everybody that has participated in today's meeting. And I believe we will be adjourned. It's 12:34.